Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Before we get started, this episode is a continuing series on the trial readings for the Darlie Routier case, a mother who in 1996 was accused and convicted of murdering two of her children in Rowlett, Texas, and who currently sits on death row. As soon as the trial readings are done, I'll be back to doing weekly true crime and paranormal cases. Now, this podcast, if you aren't aware, also has a brand new merch store, which you can get to at beachhouse34.shop. And I'll also have a link for you in the show notes. So go grab your favorite t-shirt or sweatshirt with true crime sayings, or you can get Beach House 34 logo merch for 15% off by using the code LOGO, LOGO. In the previous episode, we heard the second part of testimony from Dr. Clayton, a psychologist who spent over 12 and a half hours speaking with Darlie. She also interviewed Cyrilda, Darren's mom, and Darlie Key, Darlie's mother. We learned that the statement that Darlie gave to the doctor was very similar to the one that she gave the police. And we also learned about a suspect that the Routiers mentioned to the police, and then learned about what was said between Darren and Darlie the night before the crime occurred. So if you're interested in hearing that, I'll have the link for that in the show notes. What you're about to hear is the transcript for Arenda Langford, Darren's sister, and then testimony from Lloyd Harrell, a private investigator and former FBI agent who analyzed the 911 call. The kicker, though, he wasn't allowed to testify in front of the jury. So while you get to hear this, the jury did not. After these two witnesses, we hear from Darlie. Darlie's testimony is actually quite long, so it will cover several episodes, and I expect the first one to be out on Tuesday, July 9th, 2024. So with all that said, let's get on with the testimony. And we begin with the testimony, or the non-testimony, as it were, of Arenda Langford, and this is actually Darren's sister. So the court says, all right, are both sides ready? Mr. Greg Davis of the prosecution says, yes, sir, the state is ready. Mr. Mosty of the defense says, yes, Your Honor, we are ready. And the court says, bring the jury in, at which point the jury is then brought into the courtroom. And the court continues and says, all right, good morning, ladies and gentlemen, be seated. Let the record reflect that all parties in the trial are present and the jury is seated. The defense may call its next witness. And Mr. Preston Douglas, who is an assistant to Mr. Mulder of the defense team, says, Arenda Langford. And the court says, would you raise your right hand? So the witness at this point is sworn in. And at this point, Mr. Greg Davis of the prosecution says, may we approach? And the court says, all right. And at this point, there's a discussion that is held at the bench between the court and the attorneys and outside of the hearing of the jury. And then the proceedings were then resumed on record. And Mr. Mulder then says, Judge, we need to go into a matter. And the court says, well, if the jury will step back into the jury room briefly, please. So then the jury has to go back into the jury room. And the court says, let the record reflect that all parties in the trial are present. These proceedings are being held outside the presence of the jury. Mr. Mulder. And then Mr. Preston Douglas, again, of the defense team, says, Your Honor, if I might. And the court says, oh, excuse me, Mr. Douglas. And Mr. Douglas says, if I may go into the issue regarding Arenda. Arenda Langford was called inadvertently. She had sat in the courtroom during what I believe was Tom Bevel's testimony. It was inadvertently not recognized by us. Her testimony does not go to any issue that Tom Bevel testified to. She gained no knowledge with respect to her testimony, with respect to issues that she saw when she was in the courtroom. The witness sequestration rule and the rule against a witness being in court is discretionary with the court. And if it does not affect their testimony, it's purely discretionary. And the court can allow that witness to testify if those issues do not go to issues that she saw or witnessed in the courtroom. And for that reason, we would submit that she is capable to testify and not exempt under the rule. And if she should not be allowed to testify, we need to do a bill. The court says, well, do a bill then, because I'm not going to let anybody who has been in the courtroom is not going to testify. That is discretionary, and so I'm going to exercise my discretion and not let her testify. Mr. Douglas says, Your Honor, while we're on that issue then, the next witness that we're going to call is Lloyd Harrell, who, of course, is our investigator. His testimony would not go to any factual issue in the case at all. His testimony will be a summary and a review of the 911 tape, which has been entered into evidence and does not go into any factual issue regarding the case, but only the evidence which has been entered by the state and his review of the evidence. The court says, all right, same ruling. Let's get on with making your bill, whatever you want to do. Mr. Mulder says, well, I guess, Judge, we can do it the easy way or we can do it the hard way. And I'm equally adept at doing it either way. In fact, I kind of like it the hard way. The court says, very well, Mr. Mulder, what I wish to know is, do you wish to make a bill? Mr. Mulder says, well, we can bring their witness back and put in our version through him, or we can do it the easy way. Now, whichever the court would prefer. The court says, well, I think we had better do it the proper way, which would be to exclude all witnesses who have been in the courtroom, and any other witness you wish to call, please feel free to do so. Mr. Mulder says, well, now, I told you at the time that Bevel testified that that his memory was less than accurate as to what I had asked him in Oklahoma City. And I told you at that time I intended to testify if the court will recall. The court says, well, I know, Mr. Mulder, but things often said in the heat of battle, I don't take them too seriously. So let's get on with your next witness who has not been in the courtroom, please, or who has already testified under the rule and you wish to bring him back. Do you wish to call a witness from the state, bring the state's witness in? Mr. Mulder says, Judge, let us just put it on record. And the court says, go ahead. And Mr. Hagler, again with the defense, says, okay, Your Honor, at this time, what we want to do is we want to state to the court what these two witnesses would testify to. And the court says that will be fine. Mr. Hagler says, and then what our position is in this. Of course, the rule is found under Rule 613 under the Rules of Criminal Evidence. The court says yes. Mr. Hagler continues. The court knows it's not a per se exclusionary rule. This court has discretion depending on the type of witness, the type of testimony, and the circumstances under which the witness is called. There is also a distinction between an intentional act on the part of the defense to violate the rule and whether or not the rule was violated unintentionally by the defense. In both of these instances, Your Honor, as far as Lloyd Harrell's testimony, we had no idea what Bevel was going to testify to. And we intend to make an offer here as to what we would show through Lloyd Harrell. A requirement that he testify now is to rebut and impeach the testimony of Bevel, which we would further submit as crucial to our evidence. Now, I know the court has read, and I know the court is aware of the Webb case, 766 Southwest 2nd, 236, 766 Southwest 2nd, 236 Texas Criminal Appeal, 1989. Your Honor, this court conducts a balancing test as opposed to a per se exclusionary test. And again, the issues are, 1, the circumstances under which the rule was violated. Again, as far as Lloyd Harrell, the necessity for his testimony is required only because of the fact that through the testimony of Bevel, we had no idea what he was going to testify to. As far as this other witness, we had no idea she was going to be in the courtroom at the time. Secondly, this court must look to see what type of testimony we're talking about. You know, is it the type of testimony that they would have been influenced by what they heard in the courtroom? And furthermore, how crucial this testimony is to the defense. And again, Your Honor, we plan to make a proffer of testimony here. But again, this testimony, we would urge the court, is going to be crucial to our defense, and it would be highly detrimental unless the jury is allowed to hear it. The court says, fine. Mr. Douglas, again with the defense, says, Your Honor, with respect to Mr. Harrell, under the court's ruling, what that would mean is when you go up to interview an expert witness, you have to take, under the court's ruling, you would have to take, in effect, take a dummy person along to verify what the expert is going to say. Then leave that person outside throughout the whole trial just in case this expert told you something different. Now, you can't anticipate that an expert who is a police officer is going to come in and say something different from the interviews. The only way you can respond to it is then to have a witness come up and say that is directly contrary to what he told us in Oklahoma. You can't anticipate it, and you certainly wouldn't expect it. So for that reason, it's an adequate waiver of the rule because we have to have some way to respond to it. Second, with respect to the 911 recording, Mr. Harrell is not adding any fact other than his transcription of the recording after a number of hours of listening to it. And so, for those reasons, it does not interject any fact relating to his presence in the court. And for that reason, the rule should be waived for him for that reason. The court says, all right, the court's ruling remains the same. If you want to make a bill, let's make it. And so evidently they go ahead and they make this bill, and then Arenda is taken off of the stand, and Lloyd Harrell, the investigator for the defense, gets on the stand. And the direct examination is begun by, again, part of the defense team, Mr. Preston Douglas. Please state your name. Lloyd Harrell, Harrell. Where do you live? I live in Smith County, Texas. And how are you employed? I'm employed by Lloyd Harrell and Associates Incorporated, which is a private investigation firm. How long have you had that company? Since February of 1989. Prior to February of 1989, how were you employed? I was employed with the Federal Bureau of Investigation as a special agent. Okay. And how many years were you employed as a special agent by the Federal Bureau of Investigation? From 1965 until 1989. And did you have numerous duties and posts in the course of your duties with the Federal Bureau of Investigation? Yes, sir, I did. And can you tell, for the purposes of this bill, can you set forth what your prior experience was? I began my career as a special agent with the FBI in Butte, Montana. And then I moved to Pocatello, Idaho, where from there I moved to Wichita Falls, Texas. And from there I moved to Dallas, Texas. And then in 1980, I moved to Tyler, Texas. During that period of time, I investigated general criminal matters, crimes on government reservations, crimes on military reservations, white-collar crime, counterintelligence, terrorism, and major white-collar crime. And in the course of your duties with the Federal Bureau of Investigation, did you have opportunities to listen to recorded conversations or recordings of events and make transcriptions of those events? Yes, sir, I did. Okay. And with respect to the state of Texas versus Darlie Routier, have you been employed as an investigator for the defense in that trial? Yes, sir, I have. Have you been in the courtroom during the trial and observed various portions of the trial? Yes, sir, I have. In the course of the trial, has it come to your attention that the state has introduced a transcription which has been admitted in evidence as State's Exhibit 18-E? Yes, sir, it has. And is that a transcription of a laser disc reproduction of the 911 call? Yes, sir, it is. I'm going to hand you State's Exhibit 18-E, and I'm going to ask you if you had reviewed that transcription in comparison with the 911 Laserdisc and the call that was put in evidence by the state. Yes, sir, I have. Mr. Harrell, the Laserdisc has been marked and admitted into evidence as 18-C. Have you and I, over the course of about the last 2 weeks, spent a number of hours reviewing the sound reproduction on State's Exhibit 18-C in comparison with the transcript produced to the jury by the state embodied in the transcription 18-E? Yes, sir, we have. And do you have an opinion? Let me ask you this. How many hours would you say that you and I have reviewed the Laserdisc 18-C in comparison with the transcription 18-E? Probably about 4.5 hours. And has some of that time been spent reviewing with other members of the defense team? Yes, sir, it has. All right. And do you have an opinion as to whether or not the transcription in the State's Exhibit 18-E accurately reflects what is on the Laserdisc as State's Exhibit 18-C? No, sir, it does not. Are there material variances between the Laserdisc and the State's transcription? I believe there are. Now, have you produced a transcription based upon our review of the 911 tape? Yes, sir, I have. Mr. Douglas then says, may I approach the witness, Your Honor? And the court says, you may. And Mr. Douglas continues, Mr. Harrell, I'm going to hand you what has been marked as Defendant's Exhibit 96 and Defendant's Exhibit 96-A. Yes, sir. I'd ask you to review those exhibits. Are you familiar with them? Yes, sir, I am. And does Defendant's Exhibit 96, is that the transcription that you made based upon a review of 18-C? Yes, sir, it is. Also, would you review Defendant's Exhibit 96-A? Yes, sir. Can you tell us what that is? That is a transcription in which we have the state's version and then changed in bold, italic type, those sentences in which we believe there should be a correction. Okay. And is it your opinion that some of those changes are material in terms of what they represent from the 911 tape? Yes, sir, they are material. Mr. Douglas says, Your Honor, for the purposes of this bill, I would offer Defendant's Exhibit 96 and 96-A. And the court says, for the purposes of this bill, any objections? Mr. Davis says, no, sir. The court says Defendant's Exhibits 96 and 96-A are admitted for purposes of the bill. Mr. Douglas then continues, Your Honor, I want to, for purposes of the record, to make sure it's preserved, state to the court that it is our intention to produce, and I have available numerous copies of 96 and 96-A. It was our intention to play for the jury the 911 tape on 18-C and to produce for publication the copies of 96 as well as 96-A. So the jury could listen to the tape and make their own determination with respect to it. The court says, do you want to introduce them for all record purposes or as many as you want for record purposes, whatever you want to do? Mr. Douglas says, well, Your Honor, if I understand right, I don't feel like for the purposes of the bill, I need to put in every copy. But I want the court to understand, and I'm assuming the ruling is the same, that those transcripts are not going to be shown to the jury at this time? They will not be at this time. Mr. Douglas says, all right, Mr. Harrell, let me ask you, in the course of your duties with the Federal Bureau of Investigation, did you have training both into the federal code, which embodies all the criminal laws of the United States of America? And have you also had the opportunity to review the state penal code for the state of Texas? In some instances, yes, sir. Were you aware that in the course of your investigation that a secret recording was made at the gravesite of Devin and Damon Routier? Yes, sir, I was. And are you aware that there was a microphone placed in a bush, which is located approximately 10 to 15 feet from the graveside? Yes, sir. Based upon your experience and training as a special agent with the Federal Bureau of Investigation, do you have an opinion about whether that was a lawful act? I believe it is an unlawful act. It's against the federal law. I believe it's also against the state law. Have you reviewed the federal and state law that prohibit unlawful interception communications? Yes, sir, I have. To your knowledge, in court, has the state of Texas produced any lawful warrant or any lawful authorization by a magistrate or a judge with lawful authority enabling the state of Texas to produce or to enable the state of Texas to place that bug in a bush lawfully? We have seen no warrant or document issued by any magistrate, judge, or court which authorizes an interception for surreptitious purposes. And it's your understanding that that microphone was planted and recorded private communications that was at a prayer service on June 14th of 1996? Yes, sir. Also, when I asked you, did you travel on December 30th of 1996, I believe it is, to Oklahoma City to meet with retired Captain Tom Bevel in Oklahoma? Yes, sir, we did. Does that date sound right to you? Yes, sir. December 30th, 1996. Okay. And did you meet with Mr. Bevel? Yes, sir. And did Mr. Bevel meet with you, Richard Mosty and Doug Mulder? Yes, sir. And Curtis Glover. Okay. And the course of that conversation, did Mr. Bevel make statements regarding certain bloodstains found on defendant Darlie Routier's t-shirt? Yes, sir, he did. In your opinion, did he later make statements in court in front of the jury about certain bloodstains on the t-shirt? Yes, sir, he did. And do you believe that the statements that he made about the t-shirt in court in front of the jury are materially different from what he told you in the interview in Oklahoma City? Yes, sir, they are. Do you recall those conversations? Yes, sir. The first part of the conversation I recall is when we talked to Mr. Bevel about how he picked the particular stains to be tested. This is, of course, after the conversation occurred for some time. He indicated that the stains that he marked for Mr. Lynch to cut out and send to the DNA laboratories, gene screen, were picked for a variety of reasons. His first concern was that a stain must have directionality. He explained that directionality means in a blood stain that one axis of the stain is longer than the other one. From the axis, he can then determine the directionality, whether the stain is up or down or sideways. In order to make a proper determination, he indicated he made every effort to sample a single stain, as multiple stains may cloud the issue of directionality. Later, when we asked him about this particular issue pertaining to the individual stain sample and whose blood they contained, he said the stains contained mixtures of blood and Darlie and her children. Is that what he said in Oklahoma? Yes, sir, it is. Okay. Now, what did he say, to your recollection, in front of this jury during the trial? He, subsequent to apparently analyzing all of the DNA and the facts and circumstances of the case, he said the stains could be or were a result of a two-occurrence event, meaning both stains, that each stain sampled could have had two separate occurrences causing that particular single stain, and therefore the blood may not be mixed blood. Do you feel that that contradiction in his testimony was material and that it was directly contrary to what he had previously stated? Absolutely. For this reason, in Oklahoma City, he was asked at least twice, does this mean that each of those stains, the knife tip had to contain the blood of Darlie and the blood of one of her children? His response to that answer was yes. Now, for the purposes of the bill and purposes of the record, the t-shirt that we have been referring to is the t-shirt removed from Darlie Routier following the attack, which has been admitted into evidence as State's Exhibit number 25. Is that correct? Yes, sir, it is. And were you aware that photographs were shown to the jury in State's Exhibits 120A, 120B, 120C, 120, 121A, and 121, and that he testified to what you believe is a contradiction? Yes, sir. From not only State's Exhibit 25, but also from State's Exhibit 120A, B, 120C, 121A, 121, and 120? Yes, sir. Just going back to the 911 tape, 1 second, would you tell us why you believe it is material and important for the jury to hear the differences between the transcription in 18-E and your transcription, which is 96 and 96-A? Yes, sir. Mr. Douglas, one of the problems in developing a transcript of any taped conversation is that once you have a transcript which is written and then you hear the tape, people will tend to hear what is written. The best way to develop a transcript is to listen line by line the words that you can hear and try to develop a transcript as accurately as possible and then verify it through listening. It is very easy to misconstrue, misstate a transcript if a person reads that transcript and listens to the tape at the same time. And therefore, a transcript must be exactly accurate or as accurate as it can be in order to keep from suggesting information on the tape which is not there. Okay. You may have responded to this. I was listening to Mr. Mulder, but let me ask you this. Do you believe that when the state scrolls their version of 18-E up on the screen, that through the power of suggestion, the jury hears what is on that screen when it is not on the tape? There's two problems with it. First, they read what they hear, and they don't hear what the secondary conversation is. So if the secondary conversation, meaning the communications officer, the dispatcher, or other people occur, they don't hear that conversation. So the response may be not an answer or related to that particular piece of the conversation. So the jury, it's very suggestive to a jury, and they can hear and see what they see when in fact that is not what is being said. Mr. Harrell, the record will show what discrepancies there are, but for the purpose of this bill, I want you to go to, for instance, what you think is one of the most egregious examples of where the State's Exhibit 18-E is misleading, and explain just one or two examples of where there is significant discrepancies between 96-A and 18-E. Okay, and starting just briefly on, I will use the second minute and second reference that is in the transcript. At 35:20, which is 35 seconds and 20, the female caller in the state's version says, quote, "Though he was dead, oh my God." I hear, quote, "He's 7 years old. He is dead. Oh my God," unquote. On 39:29, I hear, quote, "I don't even know," unquote. I hear, quote, "I don't even know who did it," unquote. The state's transcription says, quote, "I don't even know," unquote, unintelligible. On 43:15, I hear, quote, "I don't even know who would do it, Darren," unquote. The state's transcription is, quote, "I don't even know," unquote, unintelligible. At 49:28, we have a major discrepancy. I hear, quote, "Who would do this," unquote. The state's transcription is, quote, "Who was breathing," unquote. At 51:15, I hear, quote, "Oh my God, who would do this," unquote. The state's transcription is, quote, "Are they still laying there," unquote. Okay, let me stop you there. Yes, sir. So in effect, if the state is going to say that their transcription, which says, quote, who was breathing, are they still laying there, unquote, is of some significance? I believe it is. Yes, sir. Would you agree that if their version is, quote, who was breathing, are they still laying there, unquote, and the correct version is, quote, who would do this? Oh my God, who would do this? Unquote. That is a material difference? Yes, sir, I believe it is. Do you believe that it is important that the jury know about this difference? Yes, sir. And going on through, without going through is it fair to say that some of these are adding in extra words? Yes, sir. But they may not change the context? And sometimes the addition has to do with the fact that in the truncated version, which appears on the screen, in order to eliminate the communications officer, they have truncated out the communications officers. So a statement made by Darlie appears to be one continuous statement, when in fact it's interrupted by communication officers making comments. Mr. Douglas says, "May I have one moment, Your Honor?" And the court says, "Sure." And then Mr. Douglas says, "For the purposes of this bill, Your Honor, I don't have any further questions." The court says, "All right. Anything, Mr. Davis?" And then there is a cross-examination by Mr. Greg Davis. "Mr. Harrell, in making this new transcript, how did you process the 911 tape?" "I didn't process the 911 tape. I listened to the Laserdisc." "Oh, so you used your ears just like I used my ears to listen to the tape?" "Yes, sir, I did." "So no processing with any software, no processing with any computer, no processing with any sort of equipment whatsoever?" "No, sir. And for the record, you have been in the courtroom the entire length of the trial, have you not?" "Yes, sir, I have." "Okay. With regards to the 911 tape, why didn't you make your own transcript before we started trial?" "We did not have the Laserdisc before trial." "You had a copy of the 911 tape, didn't you?" We did not have the copy of the Laserdisc, nor did we have the enhanced copy before trial." "Sir, did I ask you that?" "No, sir." "Would you please answer my question then? Did you have a copy of the 911 tape?" "Yes, sir, we did." Now, Mr. Harrell, with regards to Tom Bevel, you went to Oklahoma City to talk with him because you knew he would be a witness in this case, didn't you? "Yes, sir." So the fact that he testified during the course of this trial did not come as any surprise to you, did it? "No, sir." And during that meeting, it was about a 4-hour meeting with Mr. Bevel? "Yes, sir." You didn't attempt to record that meeting, did you? "No, sir." Ever ask Mr. Bevel whether it would be all right to record the meeting or not? "No, sir." Okay. So even though that was open to you, you chose not to record the meeting. Is that right? "Yes, sir." Mr. Davis says, "That's all I have, Your Honor." The court says, "You may step down. Thank you very much." "All right. Are we going to have the young lady too?" Mr. Hagler says, "Your Honor, do you want me to go ahead and make the objection now or wait until the other one?" The court says, "Well, is the young lady going to testify also?" Mr. Douglas says, "No, that's all right, Your Honor." The court says, "Just Mr. Harrell." Mr. Hagler says, "We are going to withdraw the other witness." The court says, "All right, the other witness is withdrawn." And for the record, Mr. Mulder then says, "No, Judge, we are not going to withdraw the other witness. We dictated into the record substantially what the witness would testify to, and we're satisfied with that rendition of what the witness will testify to." And the court says, "All right, that's fine." And so now Mr. Hagler says, "Okay, Your Honor, let me just kind of back up a second." The court says, "All right." Mr. Hagler says, "I want to try and break this down. And again, Your Honor, as the court knows, Rule 613 is not a per se exclusionary rule. And the Webb case, which I have already cited for the court, states that this court conducts a type of balancing test. What the court does, it looks to see, one, there is obviously a purpose for upholding the rule, and that has to be balanced against the detriment and cost to the defense and how crucial the excluded testimony is going to be. Now, furthermore, Your Honor, The court has to look to see what type of witness this is. There really are basically two types. One is an unintended witness. This is going to be a witness who, during the course of the trial, may become very important but was unknown, or the importance of that witness's testimony was unknown prior to the trial. The other category, if you want to call it that, would be one where a witness would walk into the courtroom unbeknownst to the defense, and the defense had no knowledge as to that witness's presence in the courtroom. Now, as to the lady, Arenda, I forget what her last name is now, but in that case, that would be a situation where we had no knowledge of her presence in the courtroom at the time of the testimony during the course of this trial. As far as Mr. Harrel, obviously, as being our investigator, we were certainly aware of his presence. But again, that particular type of witness, Your Honor, is going to be an unintended witness. In other words, one in which we had no knowledge prior to the trial of the importance and significance of what his testimony may be during the course of this trial. Now, Your Honor, as I understand, I have kind of broken this down into three different areas. One of them is going to be the impeachment of Bevel. Secondly is going to be the wire intercept. And third is going to be the preparation of the 911 tape. Let's take Bevel first. Your Honor, we went up and interviewed Bevel. And what I want to focus in on is that we relied on his testimony as to the fact that there was a mixture of blood on the knife tip of the alleged weapon. That evidence is going to be important, and we would submit crucial to the defense in this case, as has already been brought out and is going to be argued to the jury. We had no knowledge, Your Honor, that he was going to come down and testify in this trial that the two bloods occurred during separate occasions, as he uses the term, as opposed to one incident. That is the reason why this testimony is crucial. Again, we had no knowledge of that until he testified on the stand, at which time Mr. Harrell's testimony now becomes crucial to our defense to impeach his prior testimony. So that is the first one. And certainly we had, and again, I might add, that we're simply focusing on this one particular area. As far as the wire intercept testimony, Your Honor, they are the ones who originally injected it into this case, the matter about the graveside matter. You know, we certainly have never had any intention of doing that. That started a combination of testimony and events that ended up resulting in the testimony and the issue about the illegal wire intercept. And again, we never intended to go into this matter until it was injected into the case before the jury by the state. As far as the preparation of the 911 tape, again, we didn't have the disc until during the course of the trial. Furthermore, the preparation of it is a mere ministerial act on the part of Mr. Harrell. Certainly his presence in the courtroom wouldn't have any manner or bearing on the preparation of the tape itself. And he is subject to cross-examination like any other witness. Now, again, in all respects, this testimony is going to be crucial. And likewise, the testimony of the other lady witness, Arenda. Your Honor, to exclude this testimony would constitute a violation of our rights to compulsory process under Article 1, Section 10 of the Texas Constitution and the 5th, 6th, and 14th Amendments of the United States Constitution, and would also constitute a violation of 613 in light of the fact that if this court, and I know this court will conduct a balancing test, but certainly the importance and crucial nature of this testimony far outweighs any violation of the rule, which, again, was unknown and unintended on the part of the defense. And for all of those reasons, we would vigorously urge the court to allow Mr. Harrell and the witness, Arenda, to testify before the jury. The court says, all right. There is nothing else from either side. Mr. Davis says, no, sir. And the court says, all right, the ruling of the court remains the same. I think that the rule of evidence, first of all, the defense should have made notice of this prior to these proceedings starting if you wanted somebody in. That was not done. So I feel that the rule will take precedence in this case. I am holding that the rule does, and these witnesses will not be permitted to testify, and the bill has been made, which I think will preserve any error that there may be in this ruling. That having been done, can I see Mr. Mulder and Mr. Davis quickly, please? Mr. Greg Davis says, yes, sir. Mr. Mulder says, yes, sir. And the court says, all right, ladies and gentlemen, we do have to clear some things out, please. We do have to vacate the courtroom. All right, so let's recap. What you have just heard was never heard by the jury. But first, what I want to do is let's address Mr. Mulder's attitude. Seriously, he's kind of an ass to the judge when he says they can do it the quote easy way or the hard way. But honestly, I'm sure that he feels as if the defense has been completely screwed over during this whole trial. But he shouldn't have let his emotions get the better of him. For a case this large and this important, he should have just kept quiet or found a better way to speak to the judge. It sure didn't do him any favors. So, of course, we know that Arenda did not testify. She was not allowed to testify. And so when Lloyd Harrell got on the stand, there's a few things that we learned. So even though this private investigator and former FBI agent had significant information that was different from what the state claimed, especially what was said on the 911 call, the jury never got to hear this portion. There were quite a few areas in the original transcript that were listed as unintelligible, but Mr. Harrell was able to make them out, which in some cases changed the transcript significantly from what the jury was shown. We also hear from him, since he was a federal agent, about the laws regarding the recording at the gravesite. Now, according to Mr. Harrell, this was not done lawfully, and there were no rulings or warrants by either magistrates or judges to allow the recording at all. We then find out that at the end of December in 1996, Mr. Harrell had met with Tom Bevel, the quote-unquote blood spatter expert, and the defense attorneys. And according to Mr. Harrell, Bevel had said that he attempted to get a single stain from Darlie's t-shirt to test directionality, but he couldn't. He also said that multiple stains, when they're found together, cloud the issue of directionality. And during this meeting, he was asked twice when they met at the end of 1996 that if the knife tip causing the stains he had found had to contain the blood of both Darlie and one of her children. But on the stand, when he testified for the prosecution, he said something entirely different. Now, there's a few things that actually come up about this entire piece of his testimony. Lots of things that I got a little confused about. So, first of all, what they're doing during this testimony is that what they're doing, because it's not in front of the jury, obviously, is when they say bill, they mean that this is a bill of exception. This is a way for lawyers to disagree with the judge during trial so that this information is at least on the record and can be reviewed by an appeals court. Now, this Article 1, Section 10 of the Texas Constitution essentially protects the rights of people accused of crime, ensuring that they get a fair treatment. The Fifth Amendment protects someone from being forced to testify against themselves and ensures fair legal proceedings. And the Sixth Amendment ensures a fair trial. And finally, this Rule 613 ensures fairness when a witness's past statements are used to challenge their current testimony. So the bottom line is, even though we heard some very credible information from Mr. Harrell, the judge did not allow his testimony in front of the jury because he had been in the courtroom during the trial. And so, again, while you get to hear this, the jury did not. And that will do it for Mr. Harrell and Arenda, although she never testified or wasn't allowed to testify. Next up, we have the much anticipated testimony of Darlie, which will run several episodes. So make sure that you subscribe to the channel so that when those episodes are posted, you'll be the first to know. And again, subscribing, especially if you're on YouTube, is 100% free. Just click that subscribe button and you will get notified. So thank you all so much for listening. I'll be back very soon with the testimony of Darlie. Bye for now.